no guns or very few guns?
It's certainly approaches zero, I guess.
Okay. And as more guns get introduced into schools, does the increase of gun violence increase or decrease according to the study?
It would increase. For instance, in West Virginia, you have a little over 800 schools that are K through 12 schools, and so you'll be going from a situation in which there are very few guns in schools to which you'll have guns in many of those schools, perhaps, with this change in legislation.
Okay, thank you. Thank you, Mr. Chair.
Other questions of Mr. McJunkin? Gentleman from the 69th.
Thank you, Mr. Chairman. Mr. Duncan, these guns in schools, were they brought there by students from home, or were they brought there by school safety officers or police officers that were involved in the shootings you've...
Yes. In a number of cases, they were individuals who were charged to be there armed and had left, for instance, a pistol in the bathroom, so that that was, I think, the predominant situation in this study, that they were people there charged with that responsibility.
So, percentage-wise, would you say more shootings were caused by firearms left by people adults who brought them to school legally, or by children who brought them to school illegally?
I don't know whether I can answer that. I'm not sure.
Thank you.
Gentleman from the 88th.
Thank you, Mr. Chairman. Thank you, Mr. McGunkin. Are you familiar with Israeli policy with regards to protecting their students at schools?
No.
Would it surprise you if I told you that after the school shooting in 1974, there had, prior to at least the recent events of this past fall, have not been any school attacks in Israel?
I wasn't aware of that.
Are you aware that in Israel they have armed security guards in all of their schools, and they attribute the security of 44 years of no incidents due to that in part?
And these are security guards.
Yeah. And would it surprise you to learn that in 2 attempts, the shooters that were attacking the school were taken down by armed teachers?
Well, I hear you.
Thank you. No other questions.
Other questions of Mr. McJunkin? Other questions? Thank you, Mr. McJunkin. Thank you for being here. Does any other member seek leave to call a technical witness? If not, are there amendments? I do have one amendment at the podium. Any other amendments forthcoming? The gentleman from the 20th, Delegate Foster, seeks to amend the bill on page 3, section 11A, lines 56 and 57, by striking out the word may and inserting in lieu thereof the word shall, and on line 56 by striking the words one or more, and on line 57 after SPO inserting the following: if each person meets all qualifications of an SPO set forth in this section. So the way that would read, adopting the gentleman's amendment, would be as follows: any school district within the state shall designate elementary or secondary school teachers, administrators, or support personnel as an SPO if such person meets all qualifications of an SPO set forth in this section. Does the gentleman seek leave to explain his amendment?
I think the chairman did it quite well.
Thank you. All right. Are there questions of council regarding the gentleman's amendment? Questions of council? Gentleman from the 79th.
I understand the difference between may and shall, but I'm still trying to understand the implication of this amendment. Does this mean that every school system will have one or more SPO?
I think that is what is intended by the amendment, if I understand the amendment correctly. I'm not sure how it would how this would work together with the requirement that application for the program be voluntary, but I think the gentleman's amendment would be a shall designate. So it would be a requirement that some person be designated.
So some person in the school system or in every school?
I think the way that I understood it would be within the system.
And what if nobody comes forward to volunteer? Because this is a volunteer position that they're not
Gentleman
getting
has
paid
hit
for.
upon the observation that I made. I'm not quite sure how to reconcile those two prongs of a voluntary system with a mandatory order. I suppose a draft could be implemented. Conscription would be the only mechanism I could foresee to solve the issue.
What about a school system or a school board that finds that there are other more effective ways to protect kids rather than putting more guns in there?
Again, if the gentleman's amendment were to pass, they would be required to comply with the strictures of appointment, whether or not whatever their beliefs on it were.
So this amendment is literally saying, we don't care what local school boards think, we're going to force you to arm people in
Well,
your schools.
that's a policy statement,
Okay, thank you.
not a legal conclusion.
Thank you, Mr. Chair.
Gentleman from the 20th.
Council, just to clarify, one of the requirements is that the person being designated an SPO is that they volunteer to be, and
Yes, sir.
write that they request it.
The gentleman's absolutely correct.
So if nobody requested to be an SPO, then the school district wouldn't have to designate anybody, correct?
Well, that's not the way that I read the word shall. So that when I see the word shall, that's a non-derogable duty. And if no person applied, I would think the superintendent, his or herself, would have to come forward and do so in order for that district to be in conformity with this law if the word shall were placed in there. Some individual would have to be designated.
And the last part of the amendment that says, if such person meets all the qualifications.
But if such person did not, they would have to find someone who did. That's the way that I read the effect of the word shall. There would have to be some person comply with the full strictures of this law in order to comply with the word shall, so that the district should then therefore be in compliance. Now, there's no penalty prescribed within the law for them not being in compliance that I see, but then again, I'm not sure how this would interplay with other laws in the books.
And that's what I'm trying to understand. So if they shall designate not one or more, they don't have to designate one or more. So they shall designate an elementary or secondary school teacher, administrator, or support personnel. So if any of those people ask to be and qualify to be,
But I have an entirely different view of it. Once you insert the word shall, they must do it. The board must designate some person. It removes an element of voluntariness from the bill, in my opinion. And I don't want to go any farther than that because that gets into my opinion of legal construction. But I think most of the attorneys in this room would probably agree with me that once you insert the word shall, there is no voluntariness there. It is a non-derogable duty. They must do what they are told.
thank you.
Gentleman from the 16th.
Thank you, Mr. Chair. So, Council, I think you already answered some of my questions. The way I interpret the amendment, all 55 counties will have to do this. If
Yes,
it
sir.
passes that way.
That's precisely how I would read it. Any district would have to comply by designating some person.
In every school.
Well, in every school district. I don't know I don't have the gentleman's text in
Okay,
front of me
that's good
precisely,
enough.
but
Thanks, sir.
they would at least have to designate a person to serve.
Mr. Chair, speak to the amendment.
We're not at discussion yet.
Okay, thank you.
Other questions of council? Gentleman from the 69th.
Council, on line 58 of page 3, it says, "Responsibilities and duties of an SPO officer are voluntary."
Yes, sir.
So shall would be forcing someone, and they might not be volunteering to do this.
I think that's the circle we've been trying to square here, sir. I think you've hit it precisely.
Thank you.
Other questions of council? Gentleman from the 5th.
Mr. Chairman, council, based on my previous questioning, we had a permissive language where theoretically we could have 0 school districts who opted into this program.
Yes, sir.
Now with this amendment, where we are making it mandatory, we're having, I believe there's 57 school districts in the state of West Virginia, so we're forcing 57 school districts to opt in now?
I think that's precisely the effect of the word
Okay,
shall.
and based upon my questions earlier about Brim Insurance, theoretically why this bill may have not had a fiscal analysis is because there could have been 0 school districts. Now we know for fact 57. Do we have, has Brim given an opinion on this bill and what the cost analysis would be for each school district?
If they have, that is not something that I'm aware of at this point.
But you
Because I
agree-
think the gentleman's absolutely correct. I think because of the fact that we do not know how many would opt into a voluntary system, they can't opine as to what a total cost would be.
Correct. So now that we know at least 57 are in, for analysis purposes, you'd agree with me, this bill went from possibility of no financial impact if nobody opted in to an absolute financial impact.
Yes, I think with a may to shall, that would be the effect. Yes, sir.
Thank you.
Gentleman from the 20th.
And just question if, where the words "one or more" was stricken, if the words "available" and "voluntary" was inserted there, then they would still,
I find
it would
myself,
only be somebody who was available and voluntary.
but I find myself when they say they shall designate, I don't know how they can comply if it's merely those who are available and voluntary. I think they would, if they are required to designate, if it says they shall do so, they have been given a duty under the law, which they have sworn to uphold, that they must appoint some person. Now, again, I'm sure in the entirety of the state, every school district could find one person, or the superintendent, his or herself, could simply decide unilaterally, look, if we have to do this, I am going to be the person who stands in the gate and takes upon myself this duty so that we can be in compliance with the law. But I think that is the effect, is some person would either have to volunteer or be voluntold that they were going to be the person who undertook that duty.
So the problem, what leads to this requirement is the word "designate."
Well, I mean, the gentleman, I'm not bandying words, but I think the problem is the word shall. I think that's what gets us there. Once we move to a designation that they must do this act, there's no escaping the consequences of the act. They have to comply with the law.
Thank you.
Committee will be at ease one moment. Jeff. Gentleman from the 20th.
I'll withdraw my amendment.
Gentleman asks unanimous consent to withdraw his amendment. Is there objection? Hearing none, the amendment is withdrawn. All right, are there other amendments? If not, gentleman from the 8th to move the bill.
Thank you, Mr. Chairman. I move we report out House Bill 4299 to the full body with a recommendation that it do pass.
You heard the gentleman's motion. Is there discussion? Gentleman from the 79th.
No one else is good. Thank you, Mr. Chair. I want to thank the people in the red shirts for being here today. These questions about guns are difficult questions for us to address. They touch upon the Constitution, but they also touch upon how we protect our kids, which is one of the most important things that we as adults have to grapple with. More broadly in society, but also here in the legislature. So these are serious questions that deserve serious debate. And there's a difference of opinion about how to best protect kids. There's one school of thought that believes more and more guns are going to solve this problem. And we've seen that approach taken by the legislature. We've have all different types of armed security in schools now. We got the PROs, the SROs, the SSOs, the SPOs. If this bill passes and 4851 passes, where does it stop? How many guns are going to be enough? And there are other approaches. There are other approaches that have broad support across the state and across the country. Some of them are common sense approaches. Some of them are approaches that are not being taken. Things like addressing the safe storage of firearms, addressing the entrances and exits, and upgrading our schools to make sure that guns can't be brought into the schools. Things like reporting suspicious activity. Things like mental health care access and threat assessment teams in schools. There are other approaches that can be used that are different than just having more and more guns, more and more types of armed security in our schools. Thank you. So I can't support a bill that's just going to continue this cycle of more and more guns. So I'm a no.
Gentleman from the 88th.
Thank you, Mr. Chairman. Last year, this committee was considering a bill known as the Campus Carry Bill. Then Delegate Honaker graphically described his experiences being one of the first law enforcement officers on the scene at Virginia Tech in 2007. When he went through that description, I figured pretty much at the end of this he was going to come out very firmly against campus carry. Instead, he kind of surprised probably more than myself when he said, had there been one person that had the ability to shoot back at that shooter, there very likely would have not have been 32 people killed and 17 wounded. I was in Israel, was leading a group of Navy personnel there, and we stopped by the Red Sea, get some coffee or whatever. A school bus pulled up, and I was surprised. The first person off the school bus was somebody with a submachine gun. The last person off the school bus was somebody with a submachine gun. Unfortunately, as much as we all aspire to live in a very, peaceful world where nobody does harm, the reality is that's not the situation. After we left session last year, my wife and I went down to Nashville, and only a few days later, the school shooting occurred there. And why did that individual pick that school? Because there was nobody to shoot back. I, too, would like to live in a world where gun violence doesn't exist. I think the statistics are out there. Probably somebody here could testify to the fact that it's not the individual that's trained, has a concealed carry, that is the perpetrator, we'll say generally, of these crimes. But those are the individuals that frequently provide us a level of safety that we don't know about until it's called upon. I will be voting in favor of this bill. Thank you.
Other points of discussion? Gentleman from the 5th, followed by the gentleman from the 13th.
Thank you, Mr. Chairman. Appreciate the gentleman's comments because it made me think back to that piece of legislation. This is very similar. We passed campus carry, that is correct. The experts who actually know about their campuses, the university presidents, the staff, were all against it. But yet the legislature did it anyway. Same thing going on right now. Not a single representative of a school district is here today to support this legislation, but yet we're going to do it anyway because we're the experts. We know better. We could talk about different scenarios all day long. I just do not see a scenario in which teachers who are not qualified, not as qualified as major law enforcement, who even struggle in this scenario, look no further than Uvalde. And what happened there when the experts were in the room, the well-trained ones, and still couldn't react in time. So, this legislature just loves to claim to be experts on so many levels. And here we are again. We have qualified individuals who represent our school systems who are the real experts, and if they were here today saying that we needed this legislation, that would be different. But they're not. And I'm not going to pretend to be an expert. So I'll be voting no.
Gentleman from the 13th.
This is a hot-button topic. Some people are going to see things one way, and some people are going to see things the other. The bottom line to the whole situation, in a bad situation, we've been fortunate in the state of West Virginia. There was 38 school shootings last year in the United States of America. We've been fortunate not to have one here, but sooner or later, everywhere there's a soft target is where there's nobody to protect the kids. Law enforcement is having trouble getting people to be police officers and law enforcement all throughout the state and the United States. Sooner or later, if we don't do something to be proactive, we're going to be in trouble and we're going to wish we'd have done something. Nobody's going to give somebody a firearm that doesn't know what they're doing with it. If they can't qualify, they can't pass the class, and they can't pass the test, they're not going to get it. But, again, some of us are going to do things to make some people that want it look bad and those that don't look like heroes. If we don't do something, some of the people in this room that have kids and grandkids are not going to have them. Thank you, Mr. Speaker. I'll be voting yes.
Gentleman from the 53rd. Do you have your hand?
Yes. Thank you, Mr. Chairman. Over the past few years, I've studied bills across the country that relate to guns in some ways. And generally speaking, they fall into one of two categories. One, good bills like this that have the potential to stop a mass shooting or to stop people from getting hurt. And the other class of legislation I see are bills that would do nothing to stop individuals from being the victim of a mass shooting, that do nothing but restrict the Second Amendment rights of the people. That's it. The people who are oftentimes most likely to advance bills that are on its face for public safety don't achieve that. All they do is they restrict the individual rights of the citizens. Now, this bill right here, on its face, just reviewing it, this has the potential to save lives. The bills that are oftentimes proposed across the country, I can't recall one that is offered that in some way restricts the Second Amendment that would do anything to restrict, that would do anything to actually curb any kind of violence at all, and that would stop a mass shooting. Not one. And so if you look at this and you look at what we're trying to do here, this is one that could actually help people and that could stop violence from happening. So for those reasons, I would urge support of the bill.
Gentleman from the 86th.
Thank you, Mr. Chairman. When my friend from the 79th was questioning the gentleman representing the pediatrics, I was thinking of a gotcha question, and then I felt ashamed because I don't think there's any lack of sincerity with his presentations. I look at the moms that are here, and I understand what their fears are with regards to the safety of our kids. I'm not an expert on anything, but I may have a unique perspective. I became a father for the first time in 2005. The sheriff at that time, I had already been a law enforcement officer for 13 years at that time. The sheriff said, "We don't have any school resource officer programs in Hardy County. Would you, as a new father, I know that you would be excited at that to build one." So in 2006, I took on the task of school resource officer, but I didn't have a school that I was assigned to, but I was assigned to all 6 schools in the county. So I spent a good bit of time going from school to school, just trying to check in with the personnel that were there. I can recall, after studying ad nauseum the many school shootings, and it was just, from Parkland, or at that time it was Columbine, Jonesboro, and the list was extensive. And in every case, those school shootings were perpetrated by somebody who intended to hurt our kids. As I went around from school to school over those years, I first came to the realization that despite my best efforts, that even if I was at the Moorfield High School, the kids at the Moorfield Elementary School, had somebody come to do them harm, I would have been only the first guy there with a gun or to put a stop to it, but I would have already been too late. I'll never be able to speak as eloquently as our former Delegate Honaker, who had shared the concerns, and he said something to the effect that, he hopes that he's wrong, but God help us if he's right. The number of teachers, as I did security checks and tried to assist our school district with implementing sound policies, don't open the doors, and how to shut the door and have a place where you can hide your students. After studying all the school shootings up to that point, the reality is that they were still vulnerable. And as my daughter got into kindergarten, it was that much more worrisome, and I felt as a parent I had a natural reaction. Number one, I knew probably better than most what the vulnerabilities were, but I had other responsibilities, and I wasn't able to be there in the event that something did happen. I'll get choked up if I continue. Again, I'm not an expert, but during the course of my time in the schools, I had so many teachers that said, "Hey, is there some training? Is there something we could do?" And so many of them volunteered. They said, if y'all can set up some type of a training that would allow us to be that first line of defense, I'll do it. And I don't think there's a shortage of teachers that would be willing to take on that responsibility. When my friend from the 79th was asking the gentleman something to the effect of what's the, if there are no guns present, what are the odds that there's going to be unintended gun accident? And the answer was 0. And you can't argue with that. But if we don't have people with the children's safety as their first priority, if somebody does come with some type of a weapon or something to injure children, the chances that those kids have to be defended is zero if there's not somebody there to stop it. So I would urge passage.
Gentleman from the 76th.
Thank you, Mr. Chairman. I've heard a couple people talk about what if there's nobody to shoot back? What if there's nobody to protect the children there? I think that we have passed other legislation to deal with that with members of the public who are trained law enforcement professionals, trained military professionals that have had, in most of those instances, years of experience. And law enforcement, what a tough job that is. Not knowing and often having to assume that someone may pull a gun on you, having that training and having that restraint, I think, and still there are situations with law enforcement incidents that I'm sure are not intentional, but are accidents that happen, and somebody who may not even have a gun gets killed. We've seen that happen in society, and it happens often. And again, not as an intentional matter, but it does happen to the best trained people. And so when I look at this bill, and the training is to take a concealed carry class, which I remember hearing discussions about constitutional carry back in 2015, and most people said, well, it's so easy. Anybody can get their concealed carry permit. And so that's one requirement. The other requirement is a 24-hour training. And the difference between what we have done previously with school resource officers, protection officers, that's their job. Safety is their job. Protecting kids is their full-time job. Teachers who would be concealed carrying, who would have to have the firearm within their control, have so many other things that are going on in the course of their day and do not have the professional experience or training to potentially prevent an accident of monumental proportions from happening. Not to mention the opportunity that's there, bringing in another gun with somebody who I don't think anybody could argue is certainly not as trained and does not have the experience as the other professionals that we have talked about. And that we've passed bills to try to give them that opportunity to stop a school shooter. It's not the same. And that opportunity exists for anyone to take that gun, for the gun to be lying around. We've been lucky we haven't had a school shooting in West Virginia. And you hear, and Delegate Honecker, who was here before, what a terrible, awful story, Virginia Tech. But sometimes the most awful stories do not create good legislation. And we have to have restraint when we think and we discuss these things. And I don't think this is a good bill. I think we've done other things that try to meet the challenge that we have. And this is a pass too far. Thank you, Mr. Chairman.
Gentleman from the 8th, followed from the 69th.
Thank you, Mr. Chairman. I struggle about even wanting to say anything with regard to this bill, but I want to remind everyone around the table that we're still looking at a bill that's permissive. We're not going to mandate that every school district in the state of West Virginia do this. And I'm headed somewhere with this. My son-in-law was a school resource officer. He's no longer in that position. But we are blessed in Tyler County, or we were blessed in Tyler County, to have a school resource officer in every school. Not every county can do that. Not every city can provide an officer. We heard on the floor today where small cities in the state of West Virginia can't even afford to hire a police chief if that chief has to go be trained. So we're looking at a real dilemma and a real state of emergency with regard to the safety of our children. I have a grandson who's very soon will be the 4th generation police officer. excited about that. Proud of him already. But he will not be assigned to a school. So the question is, if we don't have enough officers in the state, and everyone around this table knows we cannot get enough officers in the state. If some counties can't afford to place an officer in there, then we're left with decisions that are difficult decisions for us to make. And I don't want to put an untrained, ill-prepared man or woman in a school who's a teacher who can't use a handgun. I don't want to do that. There is training provided to make sure that, and as I read the bill, some of the things they have to do or will be required to do is in depth. It's not like Mayberry, where we're going to give Barney a gun and say, here it is, go to it. What we have to do is realize that we're in a situation where we need to make some hard decisions with regard to school safety and our children. And no one around this table, and I want to say that I appreciate the debate today. It's been very good. But nobody around this table wants to say, man, we should have done this, we could have done that. What we want to do is say we stood up and we did what we thought was right and proper, and we're going to leave it up to the school districts as to whether or not they want to do this. If they do, they can adopt their policy, they can do this training, and they can put their teachers or other personnel, they can take care of them that way. So, Mr. Chairman, thank you for indulging me.
Gentleman from the 69th.
Chairman, I want to reflect on the last two gentlemen from 76 and the 9th that talked. They're right. The schools do need trained officers, preferably law enforcement officers, but they're not available. And those school districts, school boards don't have the money. The municipalities and cities, as you say, don't always have the money or the personnel to staff every school in West Virginia. So this is a good option to that. There's nothing like somebody that's trained, and the training they get may be minimal compared to what a professional law officer gets, but it's necessary to qualify them for this job. And the only thing that stops a bad guy with a gun is a good guy with a gun. And that's what this bill does, and I support it. Thank you.
Gentleman from the 55th.
Many of the schools have school resource officers because we have enough law enforcement to staff those positions. The school that my children go to is one of the more affluent schools in the state, and they have the resources to do that. This bill is not a mandatory requirement for any school system. I would have actually, if it would have respectfully, if it was made today, I think the decision should be left up to the local school systems. What I'm not going to do is oppose this bill and say that other school systems don't at least have the options that are available to protect my own children. There are rural communities in this state that have only a few sheriff's deputies to patrol the entire county. They have essentially no municipal police departments whatsoever. They don't have the ability at all to have a school resource officer in many schools throughout this state. Their only option would be to have some sort of voluntary program like this, or the school safety officers who we talked about just last week, I believe. So if my children are allowed to be kept safe by a police officer in school, which they are today, right now as we're sitting in this room, and other school systems on their own want to decide they want to try to keep their children safe, and the only other ways available to them, I would never tell them they don't have that right, because that would make me a hypocrite. So again, if the local school systems, as provided by this, when I have a school safety officer or a school protection officer and the choice is left up to them and they think that's what's best for the community, then I will let them make that decision. All of these different types of armed security are not going to be in all these schools. They're going to choose which one is best for them based upon their circumstances. This is a mandatory program left up to discretion of the school systems. My children have this protection. All children should if it's what's in their best interest. I'm going to vote for it.
Other points of discussion. Gentleman from the 100th.
After the Khobar Towers bombing in 1996, I was pulled
and made the Pacific Command Anti-Terrorism Operations Officer. I then did, prior to 9/11 and then after 9/11, 13 years of combating terrorism, both anti-terrorism and counterterrorism. When I was doing anti-terrorism, part of my mission was to design anti-terrorism measures and operations. One of the operations we designed was a thing called the Joint Staff Integrated Vulnerability Assessment. We did it with both the DOD leadership and the Joint Staff anti-terrorism folks, so that we could assess the vulnerability and develop measures for the installations in the Pacific Command area initially, but it then spread throughout the rest of the DOD apparatus. We had a team, and I led that team on a number of these reviews, the vulnerability assessments. We had a member of the Delta Force, U.S. Army Special Forces Delta Force, former member, as well as a member of the SEAL Team 6. In these, we would conduct a Blue Force assessment. We would look at what the Blue Forces, the installation had in terms of both their policies, procedures, weapons, et cetera, and their ability to call on resources from outside their facility, both from the host nation and from any U.S. military forces that might be in the area. We also did a red team, and that's what the Delta and the SEAL Team 6 guy were there for. They would take a look at the installation to determine how they could conduct a successful attack. Most of these were considered gun attacks because gun attacks were usually more interesting. We did look at bomb attacks. Bomb attacks are a little bit more challenging in certain respects because it's easier to get a bomb to a facility than it is to get a gun in a facility a lot of times. Two of the things that we looked at was, and it was almost the overarching criteria that we looked at as to whether or not a facility was considered secure, was whether or not there was armed security on the facility. If there wasn't armed security, then as far as we were concerned from a red team perspective, that was an ideal target. And that was something that we, as terrorists, if we were terrorists, would in fact try to use that facility as a target, as opposed to any other facilities that might have weapons. We wanted not only a present armed security, something that's visible, but also if the facility had individuals who were armed, but we could not determine whether they were armed, that was another bonus. And that further hardened the target as far as we were concerned. We looked at layers of defense. Did they have an outer layer? Did they have an inner layer? In other words, could they react if the target was penetrated and you had an ability to attack inside the target? Were there people who were going to be able to respond with weapons instantly within that facility, as well as on the perimeter? Usually the perimeter was guarded by partner nation entities. Anything inside would be a U.S. military member. Sometimes we had foreign military members inside the facility and foreign armed security inside. So we looked at these as layers of defense, and that's the way I look at what we're trying to do here. Post 9/11, after we got bombed out of the Pentagon, I was put in charge of a team that looked at models of terrorism. We studied probably hundreds of terrorist attacks, and we studied some school shootings as well, because those have very similar characteristics to terrorist attacks, and in fact they are terrorist attacks if you want to go by the definitions. During those studies, we came up with a model of terrorism. Part of the model of terrorism is we identified terrorists and terrorist groups as essentially intelligence organizations. Those groups collect intelligence before they conduct an attack. School shooters do exactly the same thing. If you look at the Columbine attack, that is exactly what those two clowns did. They looked at the school, and you saw the same thing in Nashville, where the individual, the school shooter, the terrorist, reviewed the security procedures at various locations and then decided which was the soft target. They went through then a targeting and a weaponeering phase. That's all part of a model. The key was They weren't going to face any significant resistance. They knew they didn't have to face an individual who might fire back at them, that they would have to simply wait until a police response occurred that had that type of armed response that could in fact deal with them. So the way I look at this, if you are, depending upon the police, you are talking about minutes at a minimum before you're going to get an armed response that's going to be able to deal with an armed intruder into a facility that's trying to engage targets, and those targets are our children. If you have an SPO, you may be talking tens of seconds. That individual can be in different areas of the school. He may be in another school. He may be outside the grounds. If you have a teacher who has the ability to respond instantaneously, that is the best solution for an immediate response. And that's what we're trying to get to, is get an immediate response to be able to deal with the threat as quickly as possible. If you can do that, then you have a better chance of keeping the kids alive. And that's the whole point of what we're trying to do. I would be in support of this bill. Thank you.
Other points of discussion? Gentleman from the 44th.
Mr. Chair, earlier there was reference made by the gentleman from the 5th about in Uvalde, Texas, and I believe what he said was there were experts in the room and they still couldn't stop it. Well, I hate to correct him, but there were no experts in the room. Instead, there were 20-some unarmed children, 2 unarmed teachers who were brutally murdered at point-blank range. And this is why this bill is so important, because before a shooter goes into an elementary school or middle school or high school, they're going to think twice about whether or not one of the teachers or school personnel is armed with a gun to defend their otherwise defenseless students. As a father of a 3-year-old and a 7-year-old and the husband of a teacher, I'm extremely thankful to the sponsors of this bill for having the courage to bring it up, and also for the chairman for presenting it to this committee. I support the bill. I think it's important that we have an alternative in schools that cannot afford or do not have the opportunity to have school resource officers. Just to give you an idea of the difference that this bill could make in the state of West Virginia and should make in the counties that adopt these policies. Right now, in my home county, the teachers inform me that they do what's called an Alice drill. I won't go through all of the criteria and all the steps of this drill, but basically it's duck, hide, and pray. It's you hide, barricade, and pray that you're not one of the victims of the mass shooter. One of the things that I've been told by teachers in my district is that their policy is that if a child is out in the bathroom or otherwise outside the classroom, they're instructed to barricade the doors, and at no point are they to let the child in, even if the child's knocking on the door, to let the child in. And our children, from pre-K all the way through senior high, are taught that this is how schools should be. This is what you do when school shooters appear. And while this bill may not completely protect children, it definitely provides another layer of protection. Another thing I'd like to address quickly is it was said earlier that we already have school safety officers. We already have several other mechanisms in place in some districts throughout this state. That is true, but you know we don't have. We don't have school shootings. And this adds just another layer of protection. So I would urge the passage of this bill, and thank you, Mr. Chairman.
Other points of discussion? Gentlelady from the 71st.
Thank you, Mr. Chairman. I really appreciate all of the comments, especially those last comments from the gentleman from the 44th. I had debated whether or not I would say anything, but to me, I find it interesting that in a state that has constitutional carry, we also have the ability, as we know, for teachers and school personnel and staff to have concealed carry. And yet, we ask them at the door of the schools to set aside their rights and to walk into that school, and we expect them to protect our kids. What I hope this can do with this extra training, and I am reassured by that, I'm also, I appreciate the fact that it is permissive. We're not telling any school district that they have to do this. But what I'm hoping is that we won't have football players with that vim and vigor that they have, planning how they're going to defend their classroom if something happens at their school. We won't have 5-year-olds asking their parents, what do I do? I was told to go in the corner and just be there. I want to run away and go home. We won't have kindergarten teachers, as in one instance, laying her body over top of her students. Instead, she will have something to defend herself, or he will have something to defend himself. That's why I'm a sponsor of this bill. And I'm proud as a sponsor of this bill, because you're right, our kids need protected. So I will be supporting this, and I appreciate your time.
Other points of discussion? If not, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed, no. No. The ayes appear to have it. The ayes do have it. I declare that House Bill 4299 will be reported to the floor with a recommendation that it do pass. Thank you, counsel. All right, that brings us to 4952. 4952. Committee will be at ease for just a moment. All right, 4952. Counsel, when you are ready.
Thank you, Mr. Chairman. House Bill 4952 relates to the timeframes for individuals with a right to redeem their property post a sale at a tax sale. Under current law, individuals have at least 30 days or 45 days from the time of the sale. However, as a result of some litigation, the state auditor's office is giving 150 days for individuals to redeem their property after a sale. This bill would change that so that
Counsel, hold on one second. Committee will be at ease just a minute. We are going to put this at the foot of the bills, 4952. We will go on to 5067. Can you go ahead and go do it?
Go ahead, Mr. Chairman.
Thank you, counsel.
Thank you. Thank you, Mr. Chairman, members of the committee. Turning our attention to House Bill 5067, relating to removing the 2-year time frame statute of limitations from which medical malpractice suits are to be filed for individuals who are minors when they had the medical procedures performed. It affects West Virginia Code 557B4. And it clarifies when a minor may bring a medical malpractice cause of action. The bill amends, again, 557B4 of the MPLA, which stands for the Medical Professional Liability Act. In cases relating to minors under the age of 18, the bill would allow a cause of action to be filed for a minor or on behalf of a minor within 5 years of turning 18 years old. It would be an amendment to the applicable statute of limitations. Current code defines minors for purposes of this type of action as being under the age of 10. And the code currently requires that a civil action for these individuals must be filed within 2 years of the injury or prior to the 12th birthday of the minor, whichever is later. It should be noted that adults and minors over the age of 10 have 2 years or 1 year, depending upon the type of entity that does the alleged harm by which to file an MPLA claim. Mr. Chairman, that is the bill, and I'm happy to take questions.
My committee will be at ease one moment again. Thank you.
Yes, sir.
Sorry, ladies and gentlemen, we are going to move that to the foot of the bills. We're going to go ahead and go to 5311.
Well, thank you, Mr. Chairman. I think we'll try to keep this one as brief as we possibly can.
Take your time.
Well, I don't think there's much time to take. This is a rarity. It's literally a one-sentence bill. I know this committee has a propensity to enjoy those, but that's what we have before us. This is a bill that deals with the tax treatment of real property owned by another state within the boundaries of the state of West Virginia. And the purpose of this bill is to set that tax rate. There is an existing loophole in West Virginia law on this, that it will provide that the property is taxed at the full rate of taxation unless there is an interstate compact or other agreement between West Virginia and the other state which would mitigate that assessment. That's all the bill does, Mr. Chairman.
Thank you. Are there questions of council? Gentleman from the 100th.
How much property is owned by other states inside of West Virginia? Do we have any kind of an assessment?
There is some property that I know of that is owned by other jurisdictions, but it is currently governed by an interstate compact.
So is there any property that you're aware of that would be covered by this, since that would be part of the interstate compact?
Yes, sir.
Okay. And where would that property be?
That property is the Cumberland, Maryland Airport, which is located in Wiley Ford, West Virginia. It is situated in West Virginia territory, but it is the municipal airport for the city of Cumberland, Maryland.
For Cumberland, Maryland?
Yes, sir. And the Maryland State Police maintains a state police aerial operation at that airport as well.
Okay. So the state of Maryland would then be taxed at a higher rate then?
Not at a higher rate. They would be taxed. They are currently not taxed because they and West Virginia share the cost of the airport property and are subject to an interstate compact which governs the operation of the airport. Were they to terminate that relationship and become the sole owners of that airport property, the state of West Virginia would then be able to tax the property that they own at that airport at the applicable rate.
Understand. And would you be surprised if I would be in favor of taxing Maryland to the greatest extent that we possibly could get away?
I would be astonished if you were.
Thank you. Thank you, Mr. Chairman.
Other questions of council? Questions of council? Does any member seek leave to call technical witness on this bill? If not, are there amendments? Amendments, receiving none. Gentleman from the 8th to move the bill.
Thank you, Mr. Chairman. I move House Bill 5311 be reported to the full body with a recommendation that it do pass, but first be reported to the Finance Committee.
You heard the gentleman's motion. Is there discussion? Discussion. If not, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed, no. The ayes have it. House Bill 5311 will be reported to the floor with the recommendation that it do pass, but first referred to the Committee on Finance. Ladies and gentlemen, we will be at ease for 1 minute. Delegate from the 13th.
Yes, Mr. Chairman. I got an update on Dave Fogan just a little bit ago. He has another appointment tomorrow. He had a stroke.
Committee be in order, please.
Hold on a minute.
Committee be in order. Gentleman from 13th has the floor.
He had a stroke in his eye. The doctor thinks it's due to high blood pressure. I would ask everybody, he's going to be all right. He has a couple follow-up appointments tomorrow, and the rest of the week he'll be back on Monday, hopefully. I would ask everybody to say a prayer for him, because even though he's a knucklehead, he's one of my good friends.
Is there objection, gentleman from the 8th, to say a prayer for this gentleman? Hearing none, gentleman from the 8th.
Father, you've heard that report, and we know, God, that you are there with Delegate Falgan. You know the severity. You know everything that's going on. We lift him up to you. We pray for his family as well, that you will give them peace and comfort. And we just thank you, Father, for being with him, and that you are the great physician. In Jesus' name, amen.
Amen. We will be at ease for a few minutes. to call the committee back to order. If there's anyone out in the hallway, could you holler at them and tell them we're going to come back to order? All right. You should have the correct COM sub on 4952 now before you. So we will proceed, and council, if you can just start over, that would be appreciated. 4952.
Thank you, Mr. Chairman. Sorry for the mix-up. Committee substitute for House Bill 4952 relates to the requirements for timing when property owners are redeeming property before tax deeds can be issued to purchasers from tax sales. Currently, the state auditor's office has a policy of giving owners 150 days to redeem property after a tax, or after notice has been given that their property was sold in a tax sale. This modifies that and makes it so that individuals would have 60 days to redeem their property after notice has been given.
Okay, are there questions of council? Questions of council? And so Chair has a question. Council, according to the committee substitute, when would the 60 days start ticking?
After notice has been properly given to the owner. So notice can be given in a couple of different ways. There is a case out of the Southern District of West Virginia that indirectly indicates that personal service of notice is required, but if the individual can't be personally served, publication in a newspaper or mail service, it is sufficient as long as it meets the due process requirements. So once an individual has been served, the 60 days starts.
Okay, and I'll draw your attention to page 2 of the committee substitute, lines 1 through 3. How does that define when the 60 days starts?
So section 59 of the article is relating to when the deed can be issued. Section 55, which is on page 1, is related to the service of notice.
Okay, so it says there, if after notices to redeem have been personally served or an attempt of personal service has been made or such notice have been mailed or if necessary published in accordance with the provisions of 11A355 of this code, following the deputy commissioner's sale, and then the real estate described in the notice is not redeemed within, and then it says 60 days. So that 60 days would start after service has been personally served or attempted, and then the mailed attempt, and if necessary, publication. Is that correct?
Correct, yes.
Okay. Other questions of council? Gentleman from the 63rd, I believe, 53rd.
Thank you, Mr. Chairman. So, did you say it's the policy of the auditor's office to give 120 days? Is it
Currently, they give 150.
150 days? And I'm sorry, I've got, for clarity, I've got 2 committee substitutes that have been placed in front
It's
of
the
me.
one that states 60 days.
In terms of the 150 days that's provided pursuant to the auditor's office, what is that policy based on? Is it based in statute?
No, so currently the statute sets a minimum of 45 days, but it doesn't set a cap. And so the state auditor's office has adopted the policy of 150 days based on some litigation that has.
So there's litigation going on right now, or, well, there was some court decisions on this, right?
Yes, and there is a representative from the state auditor's office that could probably speak to their policy and a bit more eloquently. The court case at issue is with respect to how notice is given. It doesn't really relate to the timing. However, there's been some other litigation from similar instances, and the state auditor has agreed to give individuals 150 days. And they can do that because there's not currently a maximum amount of time that they can give to a purchaser, or to an owner, excuse me.
Is, just inquiry of the chair, just to the room in general, is there somebody here who's familiar with that litigation at all, who could possibly talk at some point? Okay, it looks, Mr. Chairman, at the appropriate time,
Mr.
I'd like...
Rollison, at the appropriate time. Are there any other questions of council? If not, Mr. Rollison, if you would please take the microphone, introduce yourself, and I will swear you in. And who you were with, please.
Russ Rollison, I'm Senior Deputy State Auditor for the County Elections Division.
Do you swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Gentleman from the 53rd.
So, have you taken a look at this legislation?
Not the revised one.
Okay.
I knew the original one, and then I think there was one after that even.
Okay.
Thank you. Okay. Okay.
Gentleman from the 53rd.
Yes.
Yeah.
Thank you, Mr. Chairman.
Okay.
So, I just was wanting to give him a few minutes to take a look at it.
Okay.
So what is the policy of the auditor's office when it comes to service of process?
Well, that's a complicated position. Right now, we allow an individual 150 days as a result of the agreement we reached with Mountain State Justice in a case. What we have found is that the redemption rates are increased. Also, with the legislation you all passed last year, Senate Bill 552, it allowed for a payment plan option, which allowed an individual who can't come up with all the money at one time to make 3 separate payments.
Okay. Based on, I know you're just now getting this legislation, but to the best of your knowledge and what you can see based on the proposed legislation, is this proposed legislation adverse or contrary to what the agreement was? And I would assume that the agreement was adopted by a court, like a federal court or state court?
Yes.
Okay. Yes, that it was adopted?
Yes, it was a settlement agreement.
Is this language contrary to the agreement that was reached?
The agreement reached was 150 days. Anything changes to that would be different from what the agreement was reached in court. Yes, sir.
Okay.
I'm not a lawyer, but I can say that it's different. Anything lowering 150 days would be different.
Yes. Well, I mean, I'm not going to ask you whether this would open anything up and bring this thing back to court. I mean, I know you're not here to testify about that. So,
Mr. Chairman, I didn't know, was specifically wondering if there's maybe an attorney here who is familiar with the litigation that may have happened at any point,
I just have some questions about potential due process concerns with this legislation.
Are there other questions of Mr. Rollison? Gentleman from the 76th, followed by a gentleman from the 20th.
Thank you, Mr. Chairman. Thank you for being here. Sir, how has the change to 150 days, has that made the process that the task that your office has more difficult? Or can you tell me a little bit about that since the agreement was signed?
Since the agreement was reached and with the with the passage of Senate Bill 552, we have found the redemptions have increased, the percentages have increased. In addition, from last year to this year, we had 1,300 pieces of property less given to us to put up for sale, which is a pretty good amount difference from the year before, which proves that the redemptions are occurring, which makes it believable that the owners retain their interest in the property.
Okay, yeah, so that means, when you say redemptions, you mean two things. One, the taxes were paid.
Yes, sir. Yes, sir.
So the state
Which it should be, yes, sir.
State got their taxes. And number two, a property owner in the state of West Virginia didn't lose their property.
Yes, sir, exactly.
And that went up.
Where there's yes, that definitely went up. Whether they reside in West Virginia, but it is West Virginia property, yes.
Okay.
Yes, sir.
Thank you, Mr. Chairman.
Gentleman from the 20th.
Just on, when we're talking about the 150 days,
Yes.
that was just a settlement reached, but before that happened, how many days were given by standard by the auditor's office?
It quite honestly depended on whether it was publication or certified mail or whether personal service. What the personal service issue becomes is that in some cases, we're relying upon companies outside of West Virginia to serve these personal services. For instance, in California, if somebody resides in California that requires personal service, we have to rely upon an agent in California to do that. Likewise, what is more complicated than that is, and it's only happened on 1 or 2 occasions, if that individual resides on an Indian reservation, that makes it more complicated because you're operating under a different set of statutes, and you have to contact the chief of that tribe in order to get someone permissible to do that. So it varies, which adds to the length of the redemption time.
Well, and that was my question.
Yeah.
You still have, like, after service has been notified according to the bill, you still have 60 days after notice has been provided.
Yes, but when you send the notices out, there has to be a date in that. But you have to put an ending date within the notice. You can't, if you put, let's say, November 1st and send it out and say October 1st, you can't, in case of personal service, you can't believe that they're going to receive it on October 1st. There has to be some period of time. Is it 60 days from the date they receive it or 60 days from the date you send it out? I mean, I don't see how you can have it 60 days from the publication, from when it's sent out, if you don't know when they're going to receive it. They put a final date within the notice.
So this says that 60 days from when it's redeemed or or personally served.
Yes.
Or when it's published.
Yes. When you send out that notice with an end date, you don't necessarily know when it's going to be personally served. Because as in earlier discussions today on different bills, I noticed that there are counties with very few deputies available. Certain counties will not have difficulty serving personal process because there aren't any deputies available for service. There is one county will not serve it because the fees are not high enough for them to justify it. So in that case, we have to hire again an outside company to do that.
But it has to have been, before this 60-day time frame hits, it has to have been personally served. So just because you're in the process of personally serving it, the date wouldn't be until it was actually served.
But you have an end date in the notice telling them how long it's going to be to redeem it. When you send out the notices, you say you set a date that all redemptions has to be in before that particular date.
And
You don't send out the code, the way the notices are written, and I think there is a copy, there might be a copy in this bill. It gives there's an end date for each notice. The notice is good through a certain date. When you send out the notice, it's 60 days begins. The question is, when does the 60 days or any date begins, really?
And then another question on that is, we were talking about the 150 days.
Yes.
Was decided. On that, this is just putting a new statement in, so that still keeps the 45-day minimum, and it's just putting a statement in there that end time frame would be 60 days. Is that correct?
That's what I believe the intention of the bill is, sir. Yes, sir.
Okay, so, but before this, there hasn't been one at all. So it could be 300 days, could be 400, 500, like, there wasn't really any clarification as to what it would be.
There was no clarification prior to the settlement that was reached in that court case. Yes, sir. To abide by the court case, it is 150 days.
But the legislature's not bound by
Yes,
the court case.
as I understand, you are correct, sir. Yes, yes.
All right, thank you.
Gentleman from the 8th, followed by gentleman from the 55th.
Thank you, sir. It's good to see you. I'm up here.
Oh, sorry.
Good to see you.
Yes, sir.
Just a couple questions.
Sure.
Is this an issue that the auditor's office has identified as needing to be looked at by this body?
No, sir.
Would it be your testimony that the current method is working for the auditor's office and working for the people of West Virginia?
Yes, sir.
Thank you.
Gentleman from the 55th.
Just so everybody probably understands what you said, but just to be clear, let's say you all sent out a notice on January 1st.
Yes, sir.
That notice has to have a redemption deadline in the notice before it's even served on the property owner, is that right?
Yes, sir.
So let's say that your notice you send out has a redemption date of April 1st, which I know there's differences in calendar days, but for simple math, let's just say that would be, what, 90 days from January 1st? Thereabout. But let's say it takes you, 70 or 80, let's say it takes you 80 days to actually get the person served. The redemption deadline would then only be in 10 days under that circumstance, is that right?
Right, yes, sir.
Or it could take you the whole 90 days to get them served for some reason, is that
Well,
right?
in a lot of cases, we get the notices back, and then we in turn have to resend them out for one reason or another, which changes the date again.
All right, so in the past, have you had circumstances where you've actually sent out a notice and were not able to get it served by the redemption date?
Yes, and then what we had to do in certain cases, and this is particularly true with the Postal Service, sometimes they don't track their number, so what we have to do is request the individual purchasers to supply us with another name and address to do personal service on.
All right. Okay. Thank you, sir.
Gentleman from the 86th.
Thank you, Mr. Chairman. Thanks for being here. Probably in the 2 terms that I was sheriff, I sold maybe 1,000 tax liens on the courthouse steps. I'm familiar with the process, and it wasn't until we had an earlier discussion. Some of the concerns, I was one of the sheriffs in a smaller community. We had 12 deputies and maybe a part-time civil process server, and there were times that we would have a manpower shortage, whether it be sickness or somebody was on vacation or what have you. And even though, sheriffs usually go out of their way in the state of West Virginia to try to do good work for their counterparts elsewhere in the state, sometimes circumstances are such that, we're not able to make a good service. So the consequences, if there's an error in the post office, or if there's an error in the sheriff's office, the consequences for constraining this time would potentially mean that the tax lien is not redeemed, and maybe a family farm that's kind of bogged down in an estate type of a matter where, you're really not sure who to serve, or somebody hasn't come forward. There's a lot of, possible problems that sometimes would be resolved after 60 days, but before 150 days. So whether it was an agreement or not in a settlement, to have a policy of 150 days, explain the consequences once if a tax lien is not redeemed and it expires. What happens at that point to somebody, maybe a family farm that's been in 6 generations? What are the consequences?
Well, the first one that comes to mind is the purchaser gets a deed. The purchaser gets a deed. What that does is the individual who has the right to redeem, their only opportunity is one, the best opportunity they have is maybe go to the purchaser and try to work agreement out with them, or litigate it and go to circuit court, or go to federal court or circuit court. And every time I've been involved in these cases, they always bring the auditor's office in, since I'm the one that usually signs the deeds. So it consequently end up getting the auditor's office sued, involved in it, as well as the individual purchaser of the property.
Okay, and is there any cost savings that you can see to be realized by putting a cap at 60 days as in lieu of 150?
The only thing that the 60 days does really is, at one point, yes, it could make the property, it could turn the property over to a more productive owner, or whatever the case may be. That's the only savings that you could have.
Okay, so there's a potential for that cost savings, but on the same argument, there's a problem of great consequence that could result by constraining it.
Yeah, I mean, anytime you shorten the process, I think it favors the purchaser rather than the person redeeming it.
Okay. Thank you. That's all I have.
Any questions of council? Chair has a question. Mr. Rollison, isn't it generally accepted that when notice is provided by mail, notice starts on the day of mailing?
In the days when we had 45 days or 60 days, we built in a 3-day period during the U.S. mail. So if it was, so essentially, if it was dated January, whatever, we gave a 3-day leadway for expectations of receiving the notice, yes.
Okay, so yes to that. And then if it's by publication, if notice by publication, doesn't the code say in the publication statute that notice is effective on the day of first publication? Because normally these are Class 2 publications, once a day for 2 successive weeks, correct?
No, they're Class 3-0. They're Class 3-0.
Okay, and what's that?
One for every.
Once a day for 3 successive weeks?
Yes.
Okay, once a day for 3 successive weeks.
Yes.
And doesn't it define, though, that notice is effective on the date of first publication?
Yes, sir. It does, I believe. But the fact is, you're never 100% sure when that newspaper is going to publish it. You can send it to them, but not necessarily be guaranteed when it'll be published.
But the 60 days, if this were to pass, the 60 days would start in a situation of publication on the day of first publication, not when you sent it to the newspaper, not when the newspaper received it to publish it, but it would start on the day of first publication, correct?
Yes, sir.
Okay. And are a lot of these tax delinquencies just old abandoned buildings on them, dilapidated buildings and things like that?
I think what I've found out, yes, there are truly some of those. To the extent of percentages, I do not know. However, I have noticed that there seems to be, depending on which part of the state you're in, a large degree of oil and gas wells, too.
Okay, and with a new owner, until all of this is taken care of, they can't do anything to the property because there's a chance it could be redeemed, correct?
Yes, under the present law, the property remains with the current owner up to the time the deed is transferred. Yes, sir.
Okay, and currently in the code, it's a minimum of 45 days, correct?
I believe so, yes, sir.
And then there's also, on deed to purchaser, 11A 359, it talks about, but in no event prior to 30 days after notices to redeem have been personally served or attempted, or of an attempt of personal service has been made, or such notices have been mailed, or if necessary, published. So that's even a shorter time frame in that section. This ComSub would even all that out at 60 days, correct?
I believe so.
All right. Any other questions of Mr. Rollison? Thank you, Mr. Rollison. Does any other member seek leave to call another witness? Gentleman from the 94th witness?
Yes, I believe there's an attorney expert in this area. I'd like to call that person.
Is there an attorney in the room? Sir, if you'd please take the podium up here, it'd be fine. If you'd introduce yourself and who you're with. And I will swear you in.
My name is Bren Pomponio, and I am the litigation director of Mountain State Justice, a nonprofit legal service firm.
You swear or affirm that the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Gentleman from the 94th.
Thank you, Mr. Chairman. Actually, I'll defer to Delegate Credit on that. Yes.
A gentleman from the 53rd.
Thank you, Mr. Chairman. So, hello, how are you doing today?
I'm doing well. How are you?
Good. So, can you just give a little bit of background as to everything that involved the litigation with regards to these tax lien sales?
Certainly. We had a client that had alleged that she had not received proper notice of her right to redeem. And we had many other clients that had a similar complaint. At the time, the auditor's office was using a lot of a private company to provide service to individuals of their right to redeem property when the tax lien was sold. We brought the claim in federal court as a class action, and it was ultimately settled. The client died during the pendency of the litigation, but then it was settled, and the class claims were settled as part of an agreement after a mediation with Mr. Rollison being present, and the parties agreed 2 major changes to the service procedures. And one is this 150 days to redeem, and the other was that they would, to the extent that was reasonable, they would use sheriff's offices to do the personal service. And like I said, it was agreed to, and it resolved the class claims in that federal lawsuit. I don't know if there's anything else, any other details you'd like.
About when did the litigation start? What year?
It was filed in 2021.
Okay. Were there due process concerns with how everything went about in terms of these tax lien sales?
That was the basis for the case. The Supreme Court of Appeals of West Virginia, the U.S. Supreme Court, Fourth Circuit, the federal district courts have all stated that in terms of notice that of the right to redeem that a property owner is due are covered by the due process clause of the U.S. and state constitution, frankly. And that notice, it doesn't have to be personal service necessarily. That's not exactly what the court cases say, but it has to be designed to give them notice. Where it was coming up was certified mail was being returned. Everybody knew that notice had not been provided to the homeowner, and the courts have said you got to do a little more than that.
Well, my understanding, and just correct me if I'm wrong, is that there has to be at least some attempts made to serve them in person. At least attempt. I mean, that's my understanding of it. But
That's the policy of the auditor's office currently. A lot of the county clerks' policies at Kanawha County. We had a settlement with the clerk of the county commissioner for Kanawha County, in which they decided to do personal service for residential properties.
Are there any concerns with this proposed legislation?
Well, it undoes the agreement between the parties from that case and truncates the amount of time in which a borrower may redeem from 150 days after receiving notice to 60 days. A lot of people, we found a lot of our clients, the amount that is needed to redeem, they may not have paid the property taxes for a number of reasons. 911 may have changed their address, and there's some confusion for that, so the mail was never delivered. And so they didn't know that the tax tickets were never delivered, so they didn't know they were behind on their taxes. And then the amount to redeem will include costs for title searches, publication, and some interest on the back taxes that were paid. And it's a figure that is significant to our clients, thousands of dollars. And when somebody comes and says you're going to lose your home unless you pay $2,800 in 60 days, most of our clients don't have that ability. Now, the legislature did pass this installment plan where you can make 3 payments, but 3 payments over 60 days doesn't really accomplish much. 3 payments over 150 days does. We do have significant concerns with reducing the amount of time you provide property owners to redeem their property.
Do you think there's concerns in terms of this proposed change could be a violation of the property rights and due process rights of these homeowners?
Well, there have been courts that have commented on the length of time that a property owner should have to redeem, the exact time that we're talking about. And I found a case, McCann versus Scaduto, 519 Northeast 2nd 309, where they said that 60 days violated the due process clause, and that was in New York. But 60 days violated the due process clause because it was a taking without due process, where you provided only 60 days to the property owner to redeem.
Okay. All right. Mr. Chairman, I don't have any questions at this time.
Other questions of our witness, gentleman from the 20th?
And the question I have is, because my problem with this section is it's complete ambiguity in our code. So, I mean, would 300 days be enough? And this is only for somebody who has been identified, correct? It's not for unknown, unlocatable interests, because those are 2 years. Is that correct?
I'm not sure about that. I haven't represented anybody that falls in that category. I'm not familiar with that process.
Okay, and then on these, so the 60 days, my question is, when you're looking at 45, it was 45 up until just a few years ago, correct? Or was it 45, the standard practice, until the lawsuit?
Or do you mean, was that what was codified as the minimum amount of time?
Well, it was what was codified as the minimum amount of time, but
Correct.
What was the maximum amount of time?
Well, there wasn't a maximum amount of time, and but Mr. Rollison's testimony, he was talking about the difficulties in serving a notice of right to redeem, which is required to put the firm date in which the property needs to be redeemed by. And if you put 45 days from the date that you issued the notice, you could, as one of the questions was asked, you could have a situation where a property owner received that notice and the date by which they had to redeem has already passed. So the practice in the auditor's office was to put the date far enough out in their best estimation, to account for time with difficulty of service so that it could run it could give the homeowners, the property owners, plenty of time to redeem once they received it. We did see where there was problems where people would get 45 days, 60 days of notice, and that was one of the things that we negotiated in the settlement to try to make sure people had enough time. And the auditor's office, Mr. Rollison, agreed that that was an appropriate amount of time.
And in my discussions with it, like, my understanding was 120 days would meet the same requirements if we did decide to cap it at 120 days, would be time to get proper notice out. Does that sound correct or no?
Well, my understanding of this, and I'm talking about discussions that I wasn't a party of, but my understanding was this bill was introduced, and I only had a copy of that introduced bill, and it provided that there was 45 days to redeem. The title of the bill said that it was providing 60 days, but in the bill it said 45 days. And then I saw that there was a committee substitute that was circulated today that said 120 days. And so that was, to my understanding, was the result of some sort of negotiations, discussions that Mr. Rollison had with other interested parties, and that was the product of that. But that's all I know about that, 120 days.
All right, thank you.
Gentleman from the 8th.
Thank you, sir, for being here. If this stays at 60 days, will we end up back in court again, in federal court again, trying to hash through this?
Only if you know.
Only if you know. Only if you know.
Well, it would probably be our office that would pursue that type of litigation. And if we had clients coming to us that have lost their property, their homes, because they didn't have sufficient time to redeem after they received notice, we would certainly look into that. And given that there's another state that has opined about that 60-day period being a question of sufficient due process, all I can say is if we have clients coming like that, we would have to look at that. Our mission is to save homes for people, and so.
And I agree. So it would be your testimony that if complaints were to come up, let me back up. If we undo what the courts have already said is good, and we go to 60 days, then we undo everything, and it's your testimony that if you got folks lining up at your door, you'd be back there, correct?
That's correct.
Thank you.
Chair has a question. Mr.
Ponio.
Ponio, thank you. So you had this settlement and litigation. The state of West Virginia or the legislature is in no way bound by that settlement or the court, correct?
I don't want to concede that, frankly, because.
Well, was there anything in the final court order that forbade the legislature, the state of West Virginia, to enact legislation on these deadlines?
No, sir.
All right, thank you. Gentleman from the 69th.
Chairman, thank you, sir, for being here. This settlement that you reached, did that also cover raw land or mineral rights as well as people's homes?
I think our case was about residential property, and I'm not familiar with the mineral rights and how those are dealt with as opposed to surface rights. So
Okay,
I'm sorry.
thank you.
Thank you. Ladies and gentlemen, we're going to put this in a subcommittee. I believe there's another code section that needs to be looked at that's not in this bill. On the subcommittee, I'm going to appoint the gentleman from the 20th, Delegate Foster, ask him to chair the subcommittee. I'm also going to appoint the gentleman from the 53rd, Delegate Pritt, and also the gentleman from the 79th, Delegate Hanson, and ask that the subcommittee announce its time of meeting and meet and bring this back to the committee. Thank you for our guest for working on this with us. Ladies and gentlemen, that brings us to our final bill today, 5067. 5067, you should have a committee substitute on your desk that council will explain.
Thank you, Mr. Chairman. Turning our attention back to House Bill 5067, there is now a com sub in front of everyone relating to this bill. I'm going to skip straight to the analysis since I kind of went through the first parts of this a little bit earlier. Again, it does affect, however, 55-7B4 relating to statutes of limitation. The committee substitute would amend the current existing code to provide that in cases relating to minors under the age of 18, the bill would allow a cause of action to be filed for a minor within 2 years of turning 18 years old. This would be an amendment to the applicable statute of limitations, as the current code again defines minors as being under the age of 10 for purposes of this of the MPLA, and the code currently requires that a civil action must be filed within 2 years of the injury or prior to the 12th birthday, whichever is later. Mr. Chairman, that is the committee substitute, and I'm happy to take questions.
Thank you. Questions of council? Questions of council? If not, does any member seek leave to call a witness? If not, are there amendments? Receiving none. Would the gentleman from the second please do the honor of moving the committee substitute?
Mr. Chairman, I move that House Bill 5067, as amended, be reported to the legislature with the recommendation that it do pass, as amended.
Thank you. You heard the gentleman's motion. Is there discussion? Discussion. If not, all in favor of the gentleman's motion, signify by saying aye.
Aye.
Opposed, no. The ayes have it. I declare the committee substitute, also the same as the bill as amended, will be reported to the floor of House Bill 5062 with a recommendation that it do pass. Any other business come before the committee? If not, gentleman from the 8th.
Thank you, Mr. Chairman. I move we adjourn.
Gentlemen from the 8th moves we adjourn. All in favor signify by saying aye. Opposed, no.